like to welcome you to the first forum of the year. I hope you'll attend many more in the course of the year. I'm Deborah Malamud. I teach, among other things, legislation in the regulatory state and employment discrimination here. So I'm delighted to be your moderator for this topic that touches on both of those issues. So it's my job to set this discussion up. Our core federal sex discrimination statutes date from the 1960s and early 1970s. Much has changed in the last 40 or 50 years in societal understandings of sex and sex discrimination. Emerging social movements have challenged us to recognize that sex is not a biological binary and that sex discrimination is not merely a matter of affording different treatment to similarly situated men and women, which is the old-fashioned notion of what sex discrimination is. Gender, which is the preferred term now both in law and in social science, is a phenomenon that is social and cultural rather than merely or even primarily biological. Gender finds expression across our lifespans in myriad and changing ways, and as a result, the law has been called upon to recognize myriad forms of gender discrimination as well. But all of this has happened with no change in those old statutes from the 1960s and 1970s. Now and in the past, federal regulatory agencies often take the lead in responding when Congress does not. And there has always been social and legal controversy when agencies interpret statutes to keep up with changing times. Now, our focus today is specifically on transgender rights. And within that sphere, we're dealing particularly with access to facilities, which has always been a core part of American anti-discrimination law. Federal anti-discrimination laws reach federally funded programs, which you may not think about it this way, but actually include all public schools and most colleges and universities. The Departments of Justice and Education, for our purposes, federal regulatory agencies, have used their powers under these old civil rights statutes to require schools and colleges to, and now I'm quoting, treat students consistent with their gender identity. And this includes their use of restrooms. The signs on our restroom doors that invite people to use the bathroom consistent with their gender identity, those are new and those are part of our compliance efforts because these regulations we're talking about affect us here in this building. North Carolina responded to this regulatory effort by passing legislation barring their schools and universities from complying with it. This has led to widespread boycotts of the state of North Carolina, including this week by the NCAA. If sports matters to you, you've heard of this. We are now in a whirlwind of litigation around this issue, which includes a pending petition of certiorari to the Supreme Court. So this is big-time stuff. On the merits, the litigation is raising constitutional issues about equal protection and privacy rights, but that won't be our focus today, although it may well come up. That's not our chief focus today. Instead, today, we are going to be focusing on another set of issues raised by the litigation. We'll be focusing on what I think of as the quintessentially legal issues of who gets to decide what the law is on this question, and through what procedures must those decisions be made. So, for example, in taking action in this field, federal agencies have used guidance documents that don't follow the legal formalities that generally apply to binding agency policymaking. The statute that governs that is called the Administrative Procedure Act. You may hear reference to that in other people's talks. Are the agencies allowed to do this? The agencies are asserting that courts must defer to their interpretation of the law. Is that right, or is this an issue that the courts ultimately are going to get to decide on their own without deferring to anybody? These are the kinds of issues that we're going to be focusing on today. If you're first years, you'll find out that you're going to take a whole course that focuses on these kinds of issues. It's called Legislation in the Regulatory State. If you've taken that class, please don't break out in hives. We told you it would be relevant to your future life, and here you go. I will also have the honor of introducing our panelists very briefly. We're going to be starting with Professor Gabriel Arklas, one of our own graduates, who's here today from the faculty at Northeastern University School of Law. His practice experience and his research interests include the intersection of gender, race, and disability in criminal law and punishment, and he'll be speaking from some of those experiences.
Great. Hi, everyone. Is the sound okay? Can people hear me? Great. So I have what's in some ways the easiest, in some ways the hardest role on this panel, which is I'm going to situate for you how bathroom issues have been a part of trans activism and trans legal advocacy in the recent past. And first, I've been asked to address just a little bit of vocabulary that we tend to use when talking about trans issues and trans communities, recognizing that in addition to being new to some of the legal issues, some people may be new to these issues as well. So just very briefly, there are many different definitions one could use for trans people. One definition is that we are people who find that the sex that we were assigned at birth is not fully accurate for us. Trans women are people who are assigned male at birth and who identify as women. Trans men are people who are assigned female at birth and identify as men. Particularly important, I think, to remember in these discussions is that there are also many trans people who do not identify as women or as men. Non-binary is one of the terms used to describe those people. And when referring to people who aren't trans, one of the common terms is cisgender, which simply means not transgender. I'm also going to give just one more possible definition for trans and gender nonconforming people, which I think can also be relevant when we're talking about the realm of discrimination. And that's people who are perceived by others not to follow social norms around gender in some significant way, in some way that's significant enough to expose people to discrimination, violence, or harassment on that basis. So that's not about how one sees themselves, that's not about how other people perceive you in relation to these still incredibly prevalent norms we have socially about gender. So with that background, I'm going to talk about the role of access to bathrooms in trans activism and trans legal advocacy in three main ways. So the first is bathroom access as bathroom access. What trans communities have done and experienced in trying to be able to simply use the restrooms. The next is going to be about how issues of bathrooms get raised when trans people and allies are advocating for things that don't, on their face, seem like they have anything to do with bathrooms. So sort of diffusing anxiety about bathrooms when it comes up in other contexts. And the last is going to be about bathrooms as a subset of sex-segregated institutions, of which we have many, if you think about it. Bathrooms is one example, but we also have homeless shelters, domestic violence shelters, prisons, jails, military, dormitories, locker rooms, sports teams. Any institution where there's a division based on a certain understanding of binary gender is going to be an institution that will sometimes clash with the existence of trans people. So to start out, talking about access to bathrooms in and of itself. When I talk about this, part of the reason why it's hard is that I have all of these different memories that are flooding me from clients, from coworkers, from friends, from my own experiences. In this building, I have this visceral memory of being so afraid to use the bathroom every single time I did for 3 years in law school and trying so hard to pretend that I wasn't afraid. I think about my friend who's now also a law professor and going to the court to support him after he got arrested for using a men's room. I think about one of my very first clients in my second summer internship who was an older Latina trans woman who was street homeless, painfully hungry, had literally nothing. And when she went to apply for public assistance, like many people, she got a number and had to wait for many hours. And when she eventually used the restroom, security then ejected her for using what they perceived as the wrong restroom and barred her from re-entering the building, so she couldn't even apply for public assistance. And I think there's still a tendency sometimes when talking about bathroom access to either trivialize it and crack jokes, or to focus solely on the anxiety and discomfort that cisgender people may experience when confronting trans people in bathrooms, or to get really abstract. And so I just wanted to take a moment to acknowledge that in terms of lived experience, it's an incredibly serious issue. And I don't think it's an exaggeration to say that at times it's actually a life or death issue. And so the sort of recent history that I'm going to talk about in terms of bathroom access, one of the strategies that people were using right around the turn of the century was working with non-discrimination laws, often state non-discrimination laws, and litigation around bathroom access. And that didn't have really great success overall. One of the cases from that time was when West Group, which you should all know from Westlaw, told one of their employees, a trans woman, that she couldn't use either the women's restroom or the men's restroom, but she had to go to another floor or another building to use a single occupancy stall. She suggested that instead they do some education on trans issues and permit her to use the restroom with the other women. They said that they would fire her if she didn't comply. She quit and sued. And that got appealed all the way up to the Supreme Court of Minnesota, and Minnesota actually had an explicitly trans-inclusive non-discrimination law. But the Supreme Court of Minnesota said that this was not actually discrimination on the basis of self-image that may differ from biological maleness or femaleness, which was how that statute had defined the protections. They said this was simply a neutral policy, so she lost that case. And I think that many of us started to shift to look to state and local agencies that were charged with enforcing non-discrimination law to start giving some guidance on how to enforce it. So in many municipalities, in particular, New York City, DC is really a leader, San Francisco, a handful of others, we were able to get some administrative guidance that would say, okay, so if you're not discriminating against trans people, part of what that means is trans people have to be able to use the facilities consistent with their gender identity, and trans people, and either recommending or requiring that at least some restrooms be made gender neutral so that everybody could access them. And so we got some more traction there, and that did help with some cases, like, I don't know if anybody knows the restaurant, the Caliente Cab Company, which is not far from here in the West Village. And when they ejected a black lesbian woman for using the women's restroom, she was able to go to court about that, or actually she went through the agency process, right? And she was able to get a good settlement out of that. So the administrative realms is something that we were using a lot, especially at the state and local level. The federal level only became possible a little bit more recently under the Obama administration and with some of the other shifts in culture. And then just to give some examples of other situations where bathrooms arise where you might not think that they would arise. Back in 2006, we were working with another local agency here, the Department of Health and Mental Hygiene, to try to make it possible for trans people to update our birth certificates to reflect our accurate sex. And we had done a lot of work with the agency and gotten them to promulgate to propose a formal rule that it seemed like we had a lot of buy-in for. There was a public hearing, lots of people testified, everybody testified in favor of it. Then the media picked up the story, and the New York Times in particular ran a sort of dreadful story that said that if we were able to get accurate birth certificates, then it would permit men in wigs to invade women's bathrooms and commit sexual assault. And there was suddenly a flurry of opposition, and the agency withdrew the proposed rule. But there was a 10th Circuit case at SETI where a trans woman was fired from her job as a bus driver. And one of the legitimate non-discriminatory reasons that they put forward was that it was possible that when she was driving the bus, she would have to use the bathroom on the way, and somebody in one of those locations might be concerned about her using the bathroom, whichever bathroom she chose. And the court accepted that as a possible legitimate, non-discriminatory reason, even though nobody had actually raised any concerns about her using any bathrooms anywhere. And then the last area that I want to touch on is just the broader area of sex-segregated facilities. Which again, as I said, there are a wide variety of institutions that are set up with an idea that there are two natural, completely separate, meaningful, apolitical, unchanging, stable gender categories. And when they run up against the sort of inconvenience existence of trans people, then often trans people get hurt. I'm wrapping up, promise.
I hate my job.
And most of my work has been how this has come up in prisons. And again, it gets used in a wide variety of contexts. Like there was an en banc First Circuit decision just last year saying that a trans woman couldn't get access to gender-affirming surgery because, in part because the court was concerned that if she got this surgery, she might not be enough of a man to continue to confine her in a men's prison, but it still wouldn't be enough of a woman to be confined in a women's prison. And clearly she had to be locked up in one of those places, therefore she couldn't have surgery. But just very, very briefly, we've also had a number of successes, and again, it has often in the past been at state and local agency levels. So we got changes in the Department of Homeless Services here in New York City to allow trans women to be in women's shelters, which has decreased street homelessness for trans women. It's not perfect by any means, but it's something. And I was a part of getting the Office of Children and Family Services here in New York also to say that trans youth in detention as juveniles may be placed based on gender identity, can have access to hormonal care if they need it, and regardless of their facility, can have clothing that matches their gender identity. So there's sort of a long history of our trying to maneuver in different ways that have often ended up being through some agency process or another to try to navigate these problems when they come up in our communities. Now I will end.
Fantastic. Thank you. I also want to welcome Professor Arkless back to the law school. He was here as a lawyering faculty member for several years, which is when I first met him. This is a great day for the lawyering faculty because Professor Scott Skinner Thompson, who will be speaking next, is a current member of the lawyering faculty. And he has taught on and does research on issues of privacy law, family law, and health law, with a particular focus on LGBTQ and HIV issues, and has been a frequent media commentator on the issues that we are dealing with today. Scott.
Thanks so much, Deborah, and thanks to all of you for taking time out of what I know are busy schedules to get engaged on this important topic. The substantive heart of the legal dispute over which bathrooms transgender people should use is how to define and determine sex within the meaning of certain federal civil rights statutes, namely Title VII and Title IX. Does it mean the sex assigned on someone's birth certificate, a particular aspect of our gender, genetic or anatomical makeup, or our gender identity? And as Deborah foregrounded, there's the procedural issue of who gets to decide. Congress, the courts, administrative agencies charged with enforcing federal law, an individual student, that student's doctor, that student's parents. These substantive and procedural issues overlap. As with many legal questions, a good place to start is the text of the relevant statute and the relevant regulations. Here, we're focusing on Title IX. Title IX provides that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program receiving federal financial assistance. The text of the statute specifically permits separate living facilities for different sexes, but the text of the statute is silent as to how sex should be defined. The Department of Education's regulations implementing Title IX likewise prohibit discrimination on the basis of sex, but provide that a recipient may provide separate toilet, locker room, and shower facilities on the basis of sex. But the regulations, too, are silent and don't provide much instruction as to how to define sex. So, what have courts said about this language? Even before the current controversy over bathrooms, courts interpreting what counts as sex discrimination under Title IX and the employment analog, Title VII, have taken a broad view of sex discrimination. Courts, including the Supreme Court in a case called Price Waterhouse v. Hopkins, have concluded that sex discrimination includes discrimination based on sex stereotyping. That is, treating someone differently based on a failure to adhere to majoritarian norms or stereotypes about how a person of that sex should behave is sex discrimination. And even Justice Scalia recognized that same-sex harassment, that is, where a man was harassed by other men, could constitute sex discrimination. As Scalia concluded in a case called Onkal, while male-on-male harassment wasn't the principal evil Congress had in mind when it passed Title VII, statutory prohibitions often go beyond the principal evil to cover comparable evils. And it is ultimately the provisions of our laws, the texts of our laws, rather than the principal concerns of our legislators at the time those laws were passed, which govern us. While not uniform, several circuit cases addressing the treatment of transgender individuals under federal sex discrimination statutes have provided robust protections for transgender individuals. For example, in Smith v. Salem, the Sixth Circuit held that a transgender woman can bring sex discrimination claims when penalized for wearing female clothes or otherwise acting feminine. The Ninth Circuit in Schwenk v. Hartford issued a similar ruling with regard to a transgender female prisoner under the Gender-Motivated Violence Act. The First and 11th Circuits have held similarly. Other circuits, such as the Seventh Circuit, have reached different conclusions. From this body of law, we step into the current controversy. Whether Title IX's prohibition on sex discrimination requires schools to permit transgender students to use bathrooms consistent with their gender identity, or permits schools to exclude trans students from such bathrooms. The issue of how schools should treat transgender students has been percolating for a few years. For example, in 2013, the Department of Education and a school district in California called Arcadia reached a settlement which required the school district to let trans male students use the male bathroom. And there have been other similar settlements since that time. And in response to complaints and questions regarding trans bathroom access, the Obama administration issued a series of interpretive documents. For example, in December 2014, Attorney General Holder issued a memo concluding that Title VII includes discrimination based on gender identity. In January of 2015, the Department of Education, Office of Civil Rights, issued an opinion letter saying Title IX regulations require students to be treated consistent with their gender identity. With those administrative guidance documents popping up, things came to a head, when in March, North Carolina passed HB 2, which conditions bathroom access on one's supposed quote-unquote biological sex, defined as the sex assigned on one's birth certificate. This is obviously directly at odds with the interpretation of Title IX that requires equal access for transgender individuals. In response to the North Carolina law, in May, the Department of Justice and Department of Education issued their most recent and most formal to date guidance. Importantly, none of the administration's Title IX interpretive documents specific to transgender bathroom access were subject to public comment or notice and comment rulemaking. However, there has been the HUD, the Housing and Urban Development Agency, recently did issue a rule that was subject to rulemaking and concluded that transgender access to shelters must be based on someone's gender identity. And this is where we get to some of the process issues which Deborah mentioned. By way of background on statutory interpretation and administrative law, courts get to decide what the statutes mean using a wide range of statutory interpretation tools, including plain meaning. However, under certain deference doctrines, one in particular called Chevron, if a court concludes that the statutory text is ambiguous, then courts will defer to the agency's permissible interpretation of that statute. But even if and similarly, under a doctrine called our deference, if an agency rule Chevron deference deals with whether or not the statutory text is ambiguous, and our deference deals with whether the regulatory language is ambiguous. If the regulatory language is ambiguous, then agencies get deference in interpreting their own rules as well. So here, in addition to the question of how the text of Title IX should be interpreted and how the text of the corresponding regulation on sex-segregated bathrooms should be interpreted, is the question of whether the administration's interpretation of its regulation and the statute are entitled to some kind of deference, if courts need to defer to them, or if the court should look straight to the text of Title IX and interpret the statute, ignoring, in essence, what the administration has to say about it. It's a complicated administrative question. My view is that because the regulation is the portion of the relevant law dealing with sex-segregated facilities, which is to say, if you recall, I said at the beginning that Title IX actually doesn't address whether bathrooms need to be sex-segregated, but that's in the regulation. That because that's the case, the administration is entitled to deference in interpreting its own regulation, assuming that the regulation is ambiguous. And as I said, it is ambiguous because the regulation doesn't define sex and the statute doesn't define sex. The Fourth Circuit, in a recent case involving a person named Gavin Grimm out of Virginia, reached this very conclusion. There, Gavin, a high school student, challenged his exclusion from male facilities, and the Fourth Circuit deferred to the agency's interpretation of Title IX and its corresponding rule, concluding that everything was ambiguous with regard to sex, and therefore, deferring to the federal government, the Fourth Circuit held that Gavin was entitled to use the bathroom entitled with his gender identity. That school district, as Deborah mentioned, has filed a cert petition with the Supreme Court, and it's not fully briefed yet, but we'll get a ruling sooner rather than later. Other courts, including a district court in the Northern District of Texas, disagree. That case involved a suit by the state of Texas and several other states challenging the Obama administration's May guidance. The district court there held that Title IX regulations were not ambiguous, that it defined sex in relation to biological differences, and therefore the agency's interpretation isn't entitled to deference, and the district court concluded that the Obama administration's, and the district court has purported to stay enforcement of the Obama administration guidance. So, separate and aside from the level of deference owed to the Obama administration, and here I'm moving back to the substantive question, is the issue of what is the best reading of the term sex in both Title IX and the corresponding regulations. Is the best reading defining sex with regard to one's gender identity, or is the best reading defining it with regard to a narrow aspect of one's sex or gender, such as one's external genitalia or the somewhat arbitrarily assigned sex that goes on someone's birth certificate? My view is that reading sex to defining sex in terms of an individual's gender identity is the best interpretation of the statute, irrespective of whether or not the agency interpretation is entitled to deference. Why is that the case? First, even dictionary definitions of sex in the 1970s suggested that sex was the sum of both our physical and behavioral characteristics. Second, as Deborah suggested in the beginning, our medical understanding of sex and gender has become more nuanced, and science now suggests that factors contributing to one's sex are multifaceted, including, yes, our external genitalia, but also our internal reproductive organs, our gender identity, our chromosomes, secondary sex characteristics, and genes. You get the point. It's not that simple. There is no one defining biological characteristic. All of our bodies are different. There's no such thing as a male body and a singular female body. Third, even if you take the definition proposed by some of the states and rely on biological sex, that doesn't resolve any ambiguity, because many people possess physical characteristics traditionally associated with more than one gender. As the Fourth Circuit observed in its Grimm decision, it's not clear that reliance on biological sex would resolve ambiguity. For example, which room would a transgender individual who had undergone gender confirmation surgery use? What about an intersex individual? What about an individual with XXY chromosomes? What about an individual who lost external genitalia in an accident? In other words, defining sex in terms of gender identity is the only interpretation that actually avoids inconsistencies and creates a uniform rule. As such, it is the best reading, and I look forward to your questions.
Thank you so much. I gave Scott an incredibly difficult task in having to do the work of actually laying out what this complex litigation is about, and I really thank him for that. We turn now to Professor Jacob Gerson, who comes to us today from Harvard Law School. He publishes extensively on issues of administrative law and statutory interpretation in many contexts. He's the author of a forthcoming article with his colleague Jeannie Suk called The Sex Bureaucracy, which explores and critiques federal agency regulation of sex and gender identity in a number of spheres, and that's why we invited him here today. So thank you.
Great. Thanks for having me, and thanks to everyone for coming. I've already learned a lot. I know I will learn a lot more as the discussion ensues. I come to the field from administrative law, which is really a field about how the government, usually administrative agencies, but all of the state, can do what they can do and the ways in which it's legal or illegal to do it. So it is a field about how to use procedural mechanisms, procedural requirements to control government conduct, generate desirable outcomes, and produce legitimate, effective, and lawful action by administrative agencies. That's kind of the whole structure and premise of the field. So what I want to try to do today is situate a part of this debate, really this one particular 2016 letter, in the context of administrative law, to really see the contours of what that litigation is looking like and I think will look like. So in 2016, the Department of Education's Office of Civil Rights, in conjunction with the Department of Justice, issued really, I think, what's the core of what we're talking about today, a Dear Colleague letter, 2016 Dear Colleague letter. And that document states many things, some of which I'll talk about, but the core, the main one, is that Title IX, which prohibits discrimination on the basis of sex, an educational institution, means internal sense of gender. And everything else in the rest of that document more or less flows from that basic premise. And that, I think, is actually a question of statutory interpretation. That term is a statutory term with this agency, this administering agency, is interpreting. And so once that's done, all the rest of the Title IX apparatus, which is a pretty extensive apparatus, you might have heard about it in the context of campus sexual assault and sexual violence, access to education, a whole range of requirements all will apply to an internal sense of gender. I think that much is totally clear, although some of those implications have not yet been entirely fleshed out. So as you've been hearing about, that substantive position is being challenged and litigated. The substantive interpretation. This is an incorrect interpretation, the argument goes. You've heard otherwise today. Okay? But it's also been challenged procedurally. That is, the way the agency chose to offer this interpretation, to make this policy, was procedurally defective. And therefore, the policy itself, whether fantastic or horrible, is unlawful or illegal or invalid. So I just want to try to explain why that is, or what the argument is. So as many of you know, when an agency, Department of Education, Environmental Protection Agency, HUD, any of these agencies make rules or equivalently regulations, that is, when they announce a new binding legal requirement that you and I or schools have to comply with, they have to comply with the Administrative Procedure Act. This is a big statute from 1946. It controls almost everything agencies do, though they have to comply with the Constitution and other statutory requirements too. And the way that agencies typically comply with that today is to use a process called notice and comment. It's called informal rulemaking, notice and comment rulemaking. It's relatively straightforward. You publish a proposed rule in the Federal Register. This is what we want to do. This is what we think. You give people a chance to send you comments. You revise your view of what's the best thing to do. You don't revise, and then you explain all those decisions. You respond to comments, and you publish a final rule, along with this concise statement of basis and purpose, which has become essentially an elaborate counter-justification. This is why we are doing what we are doing. we got this comment, here's why we don't think it's a good idea to do that, here's why we do think it's a good idea to change, and this is what we have decided. And that statement of basis and purpose, that final rule, and that statement, the response of comments, becomes the source or foundation for any subsequent litigation. That's what we're going to go challenge. Notice, public participation, reasoned explanation. You've got to give an account of why you are doing the good thing that you are doing, and judicial review. Now, these are hoops which you might like or might not. They're kind of not that extensive, but they can be a pain in the neck. They can take a long time. When you give the public a chance to comment, you have to, deal with public comments. And, if you have to litigate, you might get a judge who doesn't like what you did, and that can take a long time. And so even though these aren't crazy hoops to jump through, they're hoops. And agencies will often prefer not to do so. So the idea is if you can accomplish your ends as a government agency, that is, get everyone to comply with your vision of the law, change their behavior to comport with what you would like them to do, without having to deal with that painful process of notice and comment and litigation, you'd really, really rather to do that. It's just cheaper, it's easier, you can just do that. And as it turns out, the APA has an exception to this broad, general notice and comment requirement. So if you're just issuing an interpretive rule, or a general statement of policy, or a rule of agency practice, or procedure, or organization, you don't have to go through all that procedural formality. You don't have to jump through that hoop. And the basic idea is if you're not making law, if you're not doing something important or new or affecting rights or obligations, well, we don't care. If you're just restating what the courts have already said, no problem. If you're requiring people to submit petitions on blue paper instead of red paper, we don't need notice and comment for that kind of thing. So we have these exceptions. But the idea is that you have to really be offering a non-binding position. It has to really be tentative. You have to really be just clarifying or restating the law. And if you're not, then what you've done at the end of the day is invalid. And just to be clear, to state what I think you see already, the agency always wants to say it's merely restating or clarifying. It's not doing anything new. Don't worry about it. And the regulated parties always say the agency is imposing a new binding legal obligation, and they had to use notice and comment to do it. That's just always, always, always a procedural posture, so that won't ever change. Now, the body of law that's grown up in this area is known as the legislative rule doctrine. If the agency announcement has the force of law, or it's practically binding, even if the agency says it's not, then it's a legislative rule, and the agency has to use notice and comment to issue it for it to be valid. So what's the 2016 Dear Colleague letter? Well, according to OCR and DOJ, it's guidance. It's an opinion letter. It's guidance. Quote, this letter summarizes a school's Title IX obligations regarding transgender students and explains how the U.S. Department of Education and Justice evaluate a school's compliance. Quote, the guidance does not add requirements to applicable law. It provides information and examples to inform recipients about how the departments evaluate whether covered entities are complying. Fine. What are its terms? Quote, the departments treat a student's gender identity as the student's sex for purposes of Title IX and its implementing regulations. This means a school must not treat a transgender student differently from the way it treats other students of the same gender identity. A school may provide separate facilities on the basis of sex, but a school must allow transgender students access to such facilities consistent with their gender identity. A school may not, however, adopt or adhere to requirements that rely on overly broad generalizations or stereotypes about the differences between transgender students and other students of the same sex. Now, other Dear Colleague letters issued by the Department of Education and Office of Civil Rights, of which there have been many, so this particular agency has chosen to make policy in this particular way. That's not true of all of the federal bureaucracy, but it is true these days of OCR. So other Dear Colleague letters purport to be non-binding. They say, this is a non-binding legal document. We are advancing tentative views. about what we think people should do, but it's not mandatory. This one doesn't really do that at all. Those obligations are mandatory obligations, and I think it's hard to read the letter as imposing anything other than that. So the legality of the government's position, if that's right, turns entirely on whether these clear mandatory obligations were, quote, pre-existing and just summarized in the DCL or not. Other people know the substantive area of law better than I do, and so I would like to hear more about that. But I think at least many regulated parties perceive the DCL as imposing new obligations that they were not aware of before, and I think part of the overall public reaction is consistent with that view too. That is what one court has held so far. I suspect other courts will hold other things, and again, that turns entirely, in my view, on what the pre-existing legal obligations were before the letter was offered. Now, every so often I get a question like, why should we care about these process objections? As long as the policy is a good one, a policy that I know in my heart is just and right, why should I care about process? Indeed, would you please stop talking about process? Would you please just stop talking? And in short, even though it sounds kind of hopelessly naive, or my notes say hopefully, but I think it was hopelessly naive, I believe in administrative law. Or rather, I believe that administrative law, the set of rules that restrict how the government can act when it deals with citizens, is much, much better than the alternative. It is the administrative law analog to Churchill and democracy. It's not great, but it's sort of what we've got. Beyond that, it's the law. These obligations aren't optional. Bicameralism and presentment, as specified in Article 1, Section 7, are a huge pain in the neck if you were trying to make a good statute. If you're trying to enact change, they're awful, but they're the constitutional requirements. And I'm happy the House just can't stand up. This House can't just stand up and say, this is the new law of the land, even though the Senate and the President disagree. I view these requirements as part and parcel of that overall bundle of procedural protections. There is, I think, I hope, I know, a relationship between process and substance. It should not be too hard to imagine what a different party in control of a different Department of Education might do without procedural protections like these. And I think we should hold our party, whatever party that happens to be, to those same standards. Now, this relationship between process and substance is there. You know it's there. I know it's there. The Department of Education knows it's there. That's why the agencies are proceeding in this way. My best guess is this policy, this letter, this guidance, this rule looks different at the end of the day if it goes through notice and comment. Now, if you love this rule, the substance of it, then yeah, you should be sad that it might have to go through notice and comment. But nevertheless, it's precisely because getting public input, responding to public comments, and having to give a public account of why you are doing what you are doing, why your interpretation is in fact the best interpretation, which I think is lacking in this document, honestly, is a desirable thing. Just to put my cards on the table and I am done. Even though I truly support many, if not all, the substantive policies adopted, I do not support this way of making law. I have a belief, an evolved, derived belief, that both institutions and individuals are much more likely to do ill and err when they deviate from the set of rules governing how they are supposed to act. I think it's true of the government, I think it's true of schools, I think it's true of corporations, and I think it's true of us.
Thanks very much. So our final speaker will be Professor Sophia Lee from the University of Pennsylvania Law School. Professor Lee is a legal historian whose scholarship and teaching synthesizes constitutional law and administrative law. And she has written on administrative agencies' role in our history in shaping constitutional and civil rights law. I thought to invite her here today to answer the question, is this just what history looks like when you're living through it, or is there something different happening around this controversy than has been the case in the past? So.
Great. Well, thank you all for coming today, and thank you so much, Deborah, for inviting me. This is one of my favorite subjects to get to speak about, so I'm very happy to be here with you all today. And I'm going to now back us way, way, way out. We've been really in the nitty-gritty weeds of a very, very difficult substantive legal issue instead of procedural questions, and I'm going to take us sky high. So my role here is to put this question of who should be deciding civil rights policy in historical context, and I thought I'd approach that from a few different perspectives. I'm going to start at what I'll call the 30,000-foot level, which is really dialing out both in terms of temporal sweep and levels of abstraction. So from the sweep of American history, how unusual is what we're seeing today, and thinking at a very general plane. Then I'll take us down to about 15,000 feet, and we'll be looking mostly at the modern administrative state, what has really grown up in the wake of the New Deal. How unusual is what we're seeing in that more narrow context, and also how unusual is it in terms of the very particular forms of policymaking that we're seeing here, what we've been talking about, which is really the government giving money to people and putting strings to it, and when those strings take the form of various civil rights laws. And then close by taking us back down to the ground level, the here and now, and some of the nitty-gritty that we've been talking about. And so the overall takeaway, I hope you'll share with me at the end of this, is that, when we look at this in the big sweep, at the 30,000 foot, the 15,000 foot level, this doesn't look so new. This looks pretty usual. That said, I do think there's some noteworthy trends we see happening, or shifts in the trends that we see happening when we get close to the ground. So I'll start us out at 30,000 feet, and in the long history of agencies taking the lead on issues that today, this is not the language that people used in the 19th century, but today we think of as civil rights and civil liberties issues, and make the case that that is, in fact, how it's been throughout most of the country's history. And the fact that agencies have taken the lead, I think, is really the result of two dynamics. One is that for much of the nation's history, courts and Congress just were pretty inactive on these issues. They weren't doing much, which just left a void for agencies to fill. They became sort of the de facto deciders of these kinds of issues. The other dynamic is one we've heard a little bit about today, which was a degree of deference by both courts and Congress to agencies. Let the agencies figure it out on the ground and experiment, and then the courts will come in, or Congress will come in and codify that approach as a more formal official kind of law. So this pattern dates back to the 19th century, and I'll just give you a couple examples. What we would think of today as communications privacy law. Back then, what we thought of as, can the government, open my letters and read what's inside them, right? When we think about how we understand the kind of privacy that we have in our letters, we're back in the 19th century, the kind of Fourth Amendment protections for mail was something that was worked out largely by postal officials, and then eventually adopted by the court in a late 19th century decision called Ex parte Jackson. I'm going to drop a few names of historians throughout this, because I'm always hoping to promote the work of people who do the history of administration, in the hopes that some of you will want to go out and read this. There's a great article by Anuj Desai on this very subject, and he explains, and here I'm quoting him, that the constitutional principle voiced in Jackson was simply the Supreme Court's affirmation of long-standing law and custom in the post office, okay? Another area in the 19th century where this was very much the case was what kinds of due process protections you have when you're going before an agency and it's adjudicating some kind of claim that you have. And here, again, Congress really specified the kinds of procedures agencies should follow when they adjudicated minimally and erratically in the 19th century. And courts basically refused to review due process challenges that people brought about the ways agencies treated them in adjudications. And so here's another name to drop. Jerry Mashaw has a history of how much more administration in the 19th century looks like what we're used to in the 20th century than a lot of people think. And he describes the Supreme Court in the late 19th century as seeming, as he put it, exasperated by due process claims that were coming to the court. And he points to an opinion in which the Supreme Court insisted that, and here's a quote from the court, due process of law does not necessarily require the interference of the judicial power. Okay, so this is a time where court and Congress are really just not that interested in being involved. And so agencies filled the void. They didn't give no procedures. They actually developed fairly elaborate procedures, fairly consistent procedures. And in fact, Ms. Shaw points out that the way veterans' pensions claims were adjudicated in the 19th century doesn't look that different than the way Social Security disability claims are adjudicated today. Now, you might have complaints about the procedures in those disability claims today, and those would harken back. But the point is, agencies with a blank check didn't just do nothing. They did something, and they did something not that different than our modern system requires them to do. And this pattern really persisted throughout the 20th century, even as courts began reviewing agencies more aggressively, so they started caring more about the due process claims brought to them, and after Congress passed the APA and set these procedural requirements for the whole federal bureaucracy. So you still see agencies taking the lead in the 20th century, with court and Congress adopting or later ratifying those policies. And federal anti-discrimination law, employment discrimination law is a great example of that. Before we got Title VII of the 1964 Civil Rights Act, it was really agencies that took the lead in figuring out ways to counter employment discrimination, developed ideas that we would later come to put the label affirmative action on. And after Title VII was passed, that continued. There's a type of discrimination under Title VII called disparate impact, which really focuses on discrimination that is not necessarily intentional, but has a bad effect for a particular protected group. That was basically a concept of discrimination developed in administrative agencies in the Equal Employment Opportunity Commission and other parts of the federal government that the Supreme Court later adopted in a decision called Griggs versus Duke Power Company. The idea that pregnancy discrimination is a form of sex discrimination started in the EEOC and later was rejected by the courts but agreed to by Congress, and they passed a statute saying, yes, indeed, that is the fact. Okay, so that's 30,000 feet. If we come down to 15,000 feet, we really see the same pattern happening, even if we're looking more narrowly at agencies' use of their spending authority, like we have in the current issue around bathroom access, and if we look more recently at the modern administrative state. So think about one of the core ways the government has used its funding is in what we think of today as cooperative federalism policies, ones where the federal government basically funds programs that are administered at the state and local level. Income assistance, what we call generically welfare, has been a classic example of that. We tend to think that welfare recipients got a right to a fair hearing when the Supreme Court said so in the early 1970s, or when poverty lawyers, many of them associated with this institution, generated those kinds of claims in the late 1960s. Well, in fact, the idea that welfare recipients have due process and due process rights to a fair hearing and equal treatment rights was actually generated by federal administrators when those programs were first created in the 1930s and 1940s. So this idea of administrative agencies taking the lead, whether we're thinking in the big sweep of history or in the more recent rise of spending clause kinds of policies that are at issue here, is really nothing new. Okay, so let's come down to the ground and think a little more closely about today. And when we get to that level, I would say there are some things that seem new, or at least seem new-ish, maybe. And I think this is true both of the structures of deference that we've talked about and the various the techniques that agencies use when they take the lead on these kinds of civil rights and civil liberties policies. So first, the structures of deference. Okay, so part of what I'm saying to you is, I think for the first 150 years, really, plus of our history, courts were pretty deferential to agencies. We could maybe even go to the first 200 years and say that was the case. They have gotten less deferential over the last 50 years. At the same time, I think agencies have gotten less adventurous and more deferential towards courts. So it is more the case in the last 50 years, say, and particularly I think it's been increasingly so, that agencies, when they take the lead, tend to try to avert to some kind of judicial doctrine that supports their position. Whether or not people might agree that that's a very adventurous interpretation of that judicial doctrine or not, there is an effort to kind of dress up what they're doing as following courts rather than leading ahead of them. I think this has led to a somewhat ironic result where you have agencies citing more judicial precedent at the same time that they are receiving less deference for what they're doing from their justifications from courts. I think there's also been shifts in the forms of administrative lead taking, and this is very impressionistic, but I think the proportion of agencies of agency action in this area that is happening through these kind of guidance documents or dear colleague letters, as opposed to through notice and comment rulemaking, that sort of more elaborate procedure that we were just hearing about, or even adjudications where parties have more kind of procedural rights, I think that may be changing. I think we're seeing more action through guidance. So particularly in the spending area, I think that there has often been, guidance has been a big part of the story. And I think these two trends come together in a way that raises questions about the future of agencies taking the lead in the area of civil rights and civil liberties. We certainly have right now a court on which the conservative justices, at this point writing separately for the most part, have indicated some deep constitutional and statutory concerns with the existing deference doctrines that agencies, the deference that's given to agencies now by courts. Those same justices also seem skeptical. I think they share Professor Gerson's skepticism about agencies using guidances and seem more inclined to find that what an agency claims as a guidance document is really a substantive rule that should have been issued by notice and comment rulemaking. We don't just see this in this area, but also in the court's treatment of the president's deferred action policies for immigrants, undocumented immigrants. So I think looking to the future, probably the biggest question is not whether agencies will continue to take the lead, but how. So are they going to continue to rely so much on guidances or shift to more formal procedures that we see in adjudications or in notice and comment rulemaking? And then if they do, are courts going to continue to defer to the interpretations they produce when they, so is it just an issue of following the right procedures and then courts will be happy, or is it still, is there going to be a question of whether there's deference at all? And I don't think any of these are going to be decided by a table full of lawyers or a room full of lawyers. I think a lot's going to be decided by the elections that happen in a couple months from now.
So I want to thank all of our panelists. I think how many of you are first-year students? I think for those of you who are first-year students, you've just gotten an excellent overview of what it looks like to take a social problem and see how it develops as a legal problem. You start with the lived experience of the human beings whose lives it's going to affect. You look at legal sources and legal doctrines to understand how they shape not only what the right answer is, but who gets to make that answer. And you understand the whole experience that you've just gone through through the use of interdisciplinary methods, in our case history, to get a sense of what's really going on and what's really novel and important in our lived experience as lawyers in our modern period. So for four of you to have done that in 12 minutes each, I think is absolutely remarkable. And I will say nothing more because the rest of the time is yours. We'd like your questions. There will be people walking around with microphones, and since we're recording, if you could please take a microphone before you ask your question, that would be great. See, the general rule that happens in law school is that if you don't start talking, we're going to keep talking, and since you don't want that to happen, you should have a question. Yes, we have somebody down front.
The microphone made me hesitate to ask, but I have a question for Professor Gerson. I'm curious, from your perspective, at what point would it have been appropriate, or would it potentially in the future be appropriate for the DOJ and DOE to issue guidance? At the point that they issued the guidance, there had been the Fourth Circuit court ruling on the Gavin Grimm case, which was very specific to the guidance that they offered, and then also, a handful of other circuit court decisions interpreting sex, to also include gender identity, Price Waterhouse, Macy, and I don't remember all of the cases you named, Scott, but so at what point, would it need to be a Supreme Court decision before it's appropriate then for this federal guidance? And there's also the issue then when students complain and file OCR complaints, is it fair for DOJ to say, this is how, if it goes through our federal adjudicatory process, this is how we're going to side, and that, this being sort of a fair heads up to schools implementing?
I could just say one thing. We were told to watch out for abbreviations, so this isn't to fault you, it's to fault us. OCR is the Office of Civil Rights of the Department of Education. Okay, go ahead.
Thanks. It's a great question, thank you. So I think there are two issues. One is, suppose the agency is offering policy, let's just call it generic, which it might be doing through guidance or it might be doing through making a new rule. And if the agency is making its own legal argument, offering its own interpretation, I would, and this is just a personal view, and lots of colleagues that I respect enormously disagree with me. I would prefer more of that go through the notice and comment process, because I believe more of those outputs will in fact be better as a result. If the agency is really just stating that the Fourth Circuit and or the Supreme Court require this and doing no extra work at all, then that's okay. I don't have an objection to that. On the other hand, there's really no need for it. So I do not happen to believe, but you could tell me otherwise, and I could easily be convinced that this was understood by all at this point prior to the issuance of the DCL. And if that really was the pre-existing federal legal obligation that would be imposed on or required of all citizens in schools as a general matter, then fair enough. And then the right substantive interpretation, as I talked about in the framework, to evaluate that DCL, the Dear Colleague letter, is it did not impose any new obligations. It merely restated the law and therefore is completely valid as an exception to Section 553 of the Administrative Procedure Act. That's a merits question, and it's not a merits question that I have a strong view on. I want to try to make the framework extremely clear so that one could evaluate that merits question and point to an overall trend in more policy making being done through guidance. And then really just to emphasize that the temptation when you are doing things that way is to push the bounds a bit. That's not a characterization of this guidance. That's a substantive characterization. That's not a characterization of this guidance. But I've read a lot of guidance documents. Too many. And I'm telling you, the temptation is to push the bounds. That's true not just of guidance, it's true of deference too. So if I say to you, or the court say to you, the agency, hey, look, I don't know much really, I'm the court. You're the expert agency. Of course I'm going to defer to whatever you say is the right thing. You think, okay then, I'm the expert. I know what the right thing to do is. And you push the statute a little bit harder. You walk into court and the court says, well, I don't know, you're the agency, you're the expert. I defer to you. And you push a little bit harder. And so the cycle of administrative law historically for me is not about a trend towards deference or away from deference. It's a cycle between those two extremes. Because over time, agencies step further and further out, and at that point, courts intervene more and more aggressively. And then having intervened really aggressively for 5 or 10 years, courts look very silly, because they're not the experts, and here they are checking the agencies who know all this developing law and policy. And the question is, where in that cycle in administrative law deference and interpretation we are at the moment? Well, I don't know the answer to that.
Additional questions? Yes, we have somebody right here. Let's get you a mic.
I just have a follow-up to that question. To what extent has the cyclical nature depended on the makeup of the court and not just
Which nature, I'm sorry? The cyclical?
Cyclical.
the
yeah.
cyclical nature depended on the makeup of the court rather than just the relationship between the court and the agencies?
So my panelists might disagree. I think it is a function in part of the makeup of the court, but not in that kind of Democrat-Republican way that you might imagine. And in my view, actually, that explains less of this cycle. So I think it's almost an inevitable cycle. I don't view it as a kind of pathology or weird thing that the courts are doing or the agencies are making mistakes. I think both the courts and the agencies are reacting in completely predictable, reasonable ways. The courts know that when they really stick their nose into the business of agencies, they should be anxious about doing that. They know that Congress is supposed to make policy and the agencies are supposed to administer it. And the courts are generalists, not experts. And so they should let agencies decide what to do. Let agencies make policies. So even as courts try to intervene, they're very uncomfortable, over the course of years. And so naturally want to pull back. And when they naturally pull back, the agencies naturally want to step in. Not because they're evil, because they're doing good work. Right? Administrators are desperately, by and large, trying to do good work, to make the world better, to implement good policy. And I think that's true here. And I think probably most of us in this room think they have made good policy here. And the question is, if they have made good policy here, should we nevertheless have our own internal anxiety about how they did it? And I've tried to raise questions about that, but lots of people in the room probably don't, and on this panel probably don't, and that's totally legitimate.
Do others on the panel want to weigh in on that? I should always ask that.
Well, I guess I would just weigh in the cyclical versus trend, long-term trend part of the question, which is just to say, I think certainly if you look, say, from the New Deal to today, or maybe even from the early 20th century today, you can see a cyclical, moments of greater scrutiny and less scrutiny on the part of courts vis-a-vis agencies. But I think if you look in the grand sweep, nonetheless, there has been a move towards, I would say, less deference overall, even as there are oscillations within that process. And I also would agree that it's not, the deference versus non-deference is not always an ideological issue. It's not predictable necessarily, and how people feel about agency adventurism is not always predictable either in a partisan way. So I would by no means want to reduce it all to either a question of politics or a simple linear narrative.
And I don't have a strong view on the trends that Jacob and Sophia have been talking about, but with regard to this particular guidance, I think one way to frame it that's helpful to me at least is to ask whether or not the Department of Education and the Department of Justice are imposing a new obligation or merely recognizing the existence of transgender people within the definition of sex. And when it's framed like that, I think that, not only are the stakes are clear, but it also highlights that they're not actually doing much to the law. They're just deciding how the law that exists should treat these people who have always existed, but have for a long time been ignored.
I would be, if I
Yeah,
could just jump in,
please.
I would be curious, regardless of whether agencies have to make policy in this area through notice and comment rulemaking, I would be curious to hear my co-panelists' thoughts on whether they should do it, whether they have to or not. And I think it's not, we heard about some of the values of doing it because it is the law, or because we think that having these kinds of processes and procedures in place, notice and comment rulemaking, serve a good constraining role in agencies. But notice and comment rulemaking potentially can be also a moment for democratic deliberation on these policy questions, so they can serve other kinds of purposes. And I think back to when agencies engaged in equal employment rulemaking in the 70s, and in fact, the FCC held public hearings right here, I think somewhere not too far from NYU, and they were open to the public for people to come and speak on these questions of whether or not AT&T should have to have particular equal employment policies. And so I guess I'm curious whether you think that is regardless of its legal requirement, a good thing for administration, for law, for democracy, or a bad thing if this is the kind of area of law where actually we don't want to put it to that kind of a public process.
Gabrielle, you want to say something?
Sure. Sorry, I have many thoughts. So from a sort of, I am unapologetically completely invested in what is going to support people's lives and dignity, their health, safety, and humanity. It doesn't mean that I don't care about procedure. I actually care a lot about procedure and shifting procedure so that there are conversations among affected stakeholders and so that there's actually some deference to the most vulnerable people who are most directly impacted, which is not most of the procedures that we have legally put in place. In terms of from strategic considerations, and I'm speaking again as an advocate here, one of the things that we think about in terms of what's going to best support people's lives, dignity, health, safety, is what is going to prevent the worst change and produce the best change for right now, because people are in need right now, and also down the line. And so one of the things that we would debate in a variety of different settings is, if we can get administrative guidance right now, and if that's going to have an impact on people who are in trouble right now, then that's great, but it's easier to change, right? So if you have an actual regulation that's been done through notice and comment, it takes a little bit more to change it, because usually you need to do notice and comment again if you want to change it. Although I'll leave it to other folks to elaborate on that if you want the elaboration. So often we would want the notice and comment for a formal rulemaking, because just then it's going to be, if it's a good policy, it'll be a little bit more resistant to change under the next administration, whether we're talking state, local, or federal. Doesn't mean it can't be changed, of course, but it's a little bit more resistant to change. And also, sometimes people can use things like notice and comment periods. It doesn't usually work this way, but I mean, there is a record of tremendous community work to intervene in these processes that have done some pretty profound things. I mean, there were, if you think about this, sit-ins during the 504 Rehabilitation Act to try to get regulations passed about what accommodations for people with disabilities mean. Or if you think about, it's a moment when you can actually mobilize a lot of people to try to talk about what their actual experiences are and try to bring attention to them. So I think that there are some real reasons when it can be very helpful to go through a more formal rulemaking process. I don't think that that's an excuse not to take action now to permit trans kids to continue to be able to go to school or for anything else, right? Yeah, I'll just leave it there for now. So I think action now is great, and also I think that the further procedural processes, both it can prevent some of the backlash and it can make some of the changes last a little bit longer.
I think that's both a great place to stop and the place that we have to stop. So I want to thank all of you for coming. I know you're all busy. I want to deeply thank the panelists for making it possible to talk about these really complex issues in this compelling a way. And come to the next forum.